I think that probably the difference is just what a bunch of conservative legislators thought about it and what they were sold by some advocates who were trying to make it a super crime or had a position in the matter. I think there is no difference, right? It's a dose of the same amount of chemicals or a similar amount of chemicals. So from a difference between the two, same.
What about legally, Alan?
I think there was a case pretty recently, maybe a year or two ago, out in West Texas where a young man was found with 10 pounds of marijuana brownies, and there was very little weed per brownie, but because the law says, you have to weigh it together, it put him in the 5 to 99 range of punishment. So it can, if as a lawyer, you're praying that for just the regular weed and not the brownies or whatnot. Your client can wind up facing a whole lot of time just because he likes to eat pot.
Well, here's the issue on that, and this is something that people really need to understand, is that when it comes to concentrates, like THC concentrated into an edible form or an oil form, or even just a concentrated form for a vaporizer or something, this is a situation where people are using the product in a way that's not as detrimental to their health as smoking it. So especially like people with that use it medicinally, they don't want to smoke it. They don't like to smoke it. They will use an edible form instead. But then we have the situation where the smokable marijuana flower, the natural flower, is being diverted pre-charge, and the concentrated form of marijuana, which is actually less health risks because you're not smoking it, those people are being charged with felonies. We had a case where a grandfather was coming to visit his terminally ill granddaughter, who is 20 years old, suffering from stage 3 cancer, and brought in some brownies and is being charged with felony. He came out to our meeting and talked about what his granddaughter was going through. So the edible forms, they're not as bad for your health because you're not smoking it, they're getting hit with felonies. So that's an important thing that needs to be addressed.
I mean, it seems like to me it's very similar, well, it is similar to the disparity that happened in the federal system under crack and regular and powder cocaine.
Absolutely.
It's the exact same thing.
You have a right to know the law. Hello, my name is Ted Robinson, and I've been a practicing criminal defense attorney in Nassau County, Long Island, New York for over 40 years. My clients have often had to ask me questions about the difference between bail and bond. And this all comes down to a very simple determination. When you first appear in court on a criminal matter, you have to go to an arraignment court. An arraignment court is simply where you appear before the judge. The charges are normally read, or they waive the reading of those charges. And then after that, you enter a plea of not guilty. Once your not guilty plea has been entered, the issue of bail will come up. Now, bail means a cash amount that's posted to ensure that you will return to court when you're told to return to court. And the determination of that is based upon how secure the court is that you're actually going to come back when told to come back. So if you have a job, if you own a house, if you've been in an apartment for a prolonged period of time, if you have children that are in school, if you own a business, these are all positives for getting a lower bail set for you, because it indicates that you have firm ties to the community and that you're not about to leave all that behind just because of a violation or a misdemeanor or even a felony. So that's the idea of setting a bail bond or bail. Now, the alternatives that a judge has is, the first alternative is setting a cash bail. Cash bail is, say, $10,000, and you'd have to post $10,000 to get your release from jail. So your family would come forward, hand the clerk $10,000 in cash, and it can be done by credit card many times because they can verify now. And at that point, you'd be free on bail. Now, what that means is if you appear for every court appearance after that you're directed to appear, you will get your $10,000 back at the end of the case after you've been sentenced, plus about 3 weeks to a month, minus 3% in Nassau County for the benefit of holding your cash. Isn't that nice? Next, if you cannot afford to put $10,000 up, but you own a home or you have secured bonds or other sorts of collateral that a bail bondsman will accept, then you can go and buy an insurance bond, which will insure you coming back to court. So you go to a bail bondsman for that, and they will take a look at your history, your background, to see if you have a lengthy history, to see if you have any warrant activity. These are all things that go into the determination whether a bail bondsman will want to issue a bond for you. Now, they work with an insurance company, and so you're going to actually be paying a premium, like an insurance premium. Well, that's exactly what it is. It's an insurance premium that you pay one time, and it's a percentage of the overall amount. So I don't know exactly what the amount is because it does vary among bail bondsmen and the insurance companies, but you'll pay a percentage of that money in cash, perhaps 10 or up to 30% of the actual $10,000. And you may have to also post, you'll likely also have to post collateral, a car, a motorhome, a house, a business. And those things will be taken as collateral in the event that you don't come back to court. So in order to get that money back, you have to come to court each time you're directed to come back on time before a judge can issue a warrant. Because when they issue a warrant, they normally vacate the bail and you're picked up and you stay in jail at that point. So as long as you come back to court each and every time and you stand and face the charges and face the matter completely and go through all the way through either acquittal or sentencing, you'll get your bail or your bond back. Now, the other thing that the courts can do is they can put you into probationary, interim probation for a period of time while you're coming and going to court. And by the way, when you have a bond, you're going to be going back to see your bail bondsman. Every time you show up in court, you're going to have to go and visit your bail bondsman as well. All these things to get out of jail and to be free on bail or bond. I hope that helps. Thanks.
Imagine you're a public defender with a client accused of a serious felony. Your conversation almost always begins in jail. In the visitation room, you begin preparing him for the most important decision he has ever made. And he'll have to make that decision while sitting in a cage. The prosecution has offered a plea bargain. It expires soon. If he accepts a guilty plea, he'll get out of jail sooner than if he goes to trial. Before the plea offer expires, your investigator tries to identify and interview the prosecution's witnesses. Are they unreliable, making faulty assumptions, lying? It all matters to your client's freedom, but you're operating in the dark because you don't know who those witnesses are. Why not just ask your client what happened? That might work if you were guilty. But innocent clients can't tell you what actually happened because, for the most part, they don't know. You lay out the options for your client. He could go to trial, but a judge may detain him, which means waiting in jail for months, if not years, before a jury hears the case. The idealist in you hopes that your client will fight. You think he could win. But the realist in you recognizes that if he loses, he will go to prison, potentially for decades. The other option is he could accept the plea offer. It would mean going home sooner. It's no wonder that 95% of defendants accept plea offers. It's also no wonder that so many people exonerated of crimes like manslaughter and drug offenses originally pled guilty. Your client signs the paperwork admitting to something that you believe in your gut he did not do. The judge asks you, does either counsel know of any reason that I should not accept the defendant's guilty plea? You want to shout, yes, Your Honor. This plea is the product of an extortive system of devastating mandatory minimums and lopsided access to evidence. My client faced an impossible choice. He is saying what is necessary to avoid the possibility of losing his life to prison. Instead, you reply, no, Your Honor.
In Science in the Soul, I have a chapter on reasonable doubt, and it's about, of course, the phrase reasonable doubt comes up in courts of law, where juries are told that they must convict somebody, say, of murder, only if it's beyond reasonable doubt that they are guilty. And that sounds all very good. It should be beyond reasonable doubt. But when you think about the fact that I think about courtroom dramas, which are so popular on television, for example, and I suspect that this accurately portrays something like what goes on in real courtrooms, and I've certainly been on 3 juries myself. There is a note of suspense in the court when the jury comes back. Which way will they go? Will it be guilty or not guilty? And then if they say not guilty, certain people heave a great sigh of relief. If they say guilty, other people do. So there is a lot of doubt in the courtroom among people who've sat through the entire trial. The judge, for example, the lawyers, the audience, sat through the entire trial as the jury has. So if the jury comes in and brings in a verdict that is beyond reasonable doubt, everybody in the court should know that. If it's beyond reasonable doubt, there can be no doubt of which way the jury will jump. And yet, when the jury do give their verdict, you go, oh, how can that be if it's beyond reasonable doubt? Imagine the following experiment. Suppose that you had 2 juries listening to the same evidence. And the 2 juries, not allowed to talk to each other, they're sent off into separate jury rooms, and they come up with their own separate verdicts. Who would bet on the juries coming back with the same verdict every single time? Virtually nobody would. If you think about the O.J. Simpson trial, for example, would anybody bet on another jury coming up with the same verdict? And yet, unless you can bet, unless you can say, yes, they would come up with the same verdict, you cannot really take the phrase beyond reasonable doubt seriously. Now, I'm not suggesting that we should have 2 juries in every trial. I'm just pointing out that the phrase beyond reasonable doubt doesn't actually mean what it says.